What's up, guys? I want to take a little bit of time to discuss a criminal procedure question, which involves two major areas that are always tested and often tested together, which is a Fourth Amendment analysis and a Fifth Amendment analysis. They usually are tested together. And then a follow-up question, which deals with theft, in particular larceny and embezzlement. So I'm going to give you the facts in just a second, but I want you to pay attention to how the bar examiners ask these questions. So the first question here is Dan likely to prevail on his motion? And what he's motioning for is to suppress a gun that was found in his car and a statement that he made to the police related to the gun. Secondly, the question is, if Dan does not prevail on his motion, is he likely to be convicted at trial? Convicted of what? That goes to the issue of theft, of whether or not he can be convicted of larceny with regard to the gun or embezzlement with regard to the gun. So when you see these kind of questions, pull back for a second, because sometimes it's a little jarring. Like, well, what is he going to be convicted at trial of? What? Of driving with a gun? Of violating? What is he charged? And so it's the underlying crime. What is the underlying crime here? Think through that, and that would be the answer to the question about being convicted at trial. The answer to the question, will he prevail on his motion? He's going to try to keep out of evidence the gun because of the Fourth Amendment violation, the potential Fourth Amendment violation. He's going to try to keep out of evidence his statement. Okay? If he were to prevail on his motion, he probably wouldn't be convicted. But this says if he doesn't prevail on the motion, and that's why you have to lay out the rules for larceny and embezzlement. All right, so let's walk through it. Here's the basic facts. So this guy named Dan works at a church, and a woman, for whatever reason, decides to give a book and a gun to the church. She gives it to Dan, who is intending to bring the book and the gun to the church, but then changes his mind. Eventually, he leaves the book with the church, but he keeps the gun, and he's driving around with the gun on the front seat of his car. Why is he doing that? I don't know, but that's what he's doing. The next day after he gets the gun, he's driving around and he winds up getting stopped at a police checkpoint. It's important that when you see a police checkpoint, you watch what's happening. Are they stopping every car? Are they stopping every fifth car? Are they stopping only cars with people of a certain ethnicity, or cars that look suspicious, maybe cars that are too dirty? You want to look at what's happening, because that directly goes to, do you understand the rule of police checkpoints? They stop Dan and they say to him, we're doing a sobriety checkpoint, we're stopping every car, we'd like for you to get out of the vehicle. So they say, will you step out of the vehicle? And the facts say he's not sure if he has to get out or not, or if he can say no, so he gets out of the car. When he gets out of the car, the police see so we'll deal about consent in a second. Police see the gun on the seat. They say, hey, is that your gun? And he says something to the effect of, well, I stole it. And then by that admission, he winds up getting arrested and charged with theft. That's the essential facts of the case. Okay, let's walk through it. First things first, I want you to understand, when we're dealing with Fourth and Fifth Amendment, we're dealing with stuff. The Fourth Amendment deals with excluding stuff, physical objects, physical evidence. The Fifth Amendment deals with statements, generally confessions, right? But it could be any statement that might incriminate yourself. So let's walk through Fourth Amendment. Remember, the Fourth Amendment only applies to the government. Here, the federal government, I don't think these facts say whether it's the federal government or the state government. So you probably don't have to address whether the 14th Amendment applies. But if it was a state that was stopping him, a state police, you have to say that the 14th Amendment allows the Fourth Amendment to be applicable to the states. You could say that a little cleaner, but that's how we get the Fourth Amendment principle sort of connected to state action. So 14th Amendment. Here we can start with Fourth Amendment, state the rule. Fourth Amendment prevents unreasonable searches and seizures. State the rule. Pretty simple. Then directly kick down to government conduct. You'll see this in the sample answer. I like answer B better because it's a little bit more structured. but government conduct. Simple point. The government here is acting because the police are the ones executing the search. Standing, reasonable expectation of privacy. This is an important point. I think structurally, when you look at the facts, you notice that the gun is not his. Why is that relevant? Well, reasonable expectation of privacy is required for the person to have standing. And a reasonable expectation of privacy means you have a legitimate possessory interest in the place to be searched or the thing to be seized. Now, he probably has a reasonable expectation of privacy with regard to the car, it's his car, but he might not with the gun. And you might want to point that out. Do you have to point that out to pass? No, because that wasn't discussed in too great detail in these answers, but it is an issue that you could tease out, that he has a reasonable expectation of privacy in the car because he has a legitimate possessory interest in it, but probably not to the gun because it's not his gun. It's an interesting analysis point. If a person has standing, they have to show the government violated the Fourth Amendment by not having a warrant. Now, this question does not fully go into warrants, so you don't necessarily need to say warrants need probable cause and whatnot, but you certainly can say that a warrant is required and there was no warrant here. If there's no warrant, the government has to show that there's an exception. There's a number of exceptions. My advice to you is argue every exception that is reasonably applicable. You're going to see that certain of the exceptions are more on point than others. Start with those, and then develop a few more if you have time to do that. And you want to watch your time and kind of think. If you get a divided question like this, probably the first issue is the biggest one, the second one's middle, and the bottom one is small. So you might say, all right, I've got 45 minutes to write. I'm going to go 20 minutes on the first one. Maybe I'll go 12 minutes on the second one and X number of minutes on the third one. You want to be thinking about that as you're doing your answer to grab your time. Stay within the 60-minute block. Stay within the 60-minute block. All right, I'm watching my time right now. I got to move a little quicker. So here we go. Police checkpoint. What's the rule? The police checkpoint needs to be essentially objective in nature. It has to be sort of non-discriminatory. If it's not non-discriminatory, then this is a violation, and this would not function as a police checkpoint. Again, I'm going to move a little quick. Consent. If a person gives consent to be searched or to search an area, whether it's, hey, you can come into my house and search, yeah, sure, you can come into my car and search, yeah, sure, you can pat me down, then consent itself becomes an exception. And so that would permit the search. Plain view. This often comes into play with a consent scenario. Why? Because I say, sure, you can come into my house, and then they see drugs on a table. Now they've seen these drugs. That might give them probable cause to get a warrant to search another building I might own or something like that. But certainly what's in plain view can be seized. In this case, plain view led to seeing the gun, and so that gave them sort of in access to seize the gun. Automobiles and search incident to lawful arrest. You didn't see automobiles in these answers, but you could certainly argue automobile exception because this was an automobile. If they wanted to go and search the trunk or something like that, they would need to have probable cause to search the rest of the vehicle, and they could easily establish that when he says, hey, I stole the gun. That leads to probable cause. There could be more going on here. Search incident to lawful arrest. The problem says that he was charged with theft. So obviously he was arrested. You might say that they could search the rest of his car or even, further search him. Search incident to lawful arrest. Your main arguments are here in this problem, but I don't see an issue with tagging on these two for extra points. I think that's reasonable. The answer to the question is, will he prevail on his motion to suppress the gun? No, he won't. Why? Because the government, even though they didn't have a warrant, they had an exception, several of which would apply. He's not going to be able to exclude the gun. Now we get to his statement. And so the statement comes when the police say, hey, is that your gun? And the issue becomes, well, anytime there's a statement or a confession in particular, it triggers the Fifth Amendment analysis. It's a very simple analysis, but there are some steps, and you should learn and master the structure of Fifth Amendment analysis. First of all, you have to state the Fifth Amendment. You might also say government conduct, or you might just say government conduct rule above, see rule above. The Fifth Amendment says essentially no compelled confessions, but a person cannot be forced to incriminate themselves or to be a witness against themselves. And as a protection against that, Miranda says that a person must be given warnings that they have a right to remain silent, they have a right to an attorney, etc., and they have that right if they're in custody and they're being interrogated. So the point would be, if the person is not in custody or not being interrogated, you didn't need a Miranda warning. You're going to see this on the exam as you saw here. They didn't give him a Miranda warning, and therefore we have to look at, well, was this a custodial interrogation? Because if it was, it's a violation of Miranda, and therefore he can, in the fifth of the statement, the confession doesn't come in. Now, in looking at these facts, we see that he was asked to get out of the car, and I believe he thought to himself subjectively, believing he had no choice, he gets out of the car, and this may or may not be custody. Custody means not free to leave, but it's an objective, reasonable person standard. So here, when you lay out the heading custody, you say, essentially, give the rule, and then you want to argue, well, he didn't believe he could leave, so maybe he was in custody. Would a reasonable person believe they couldn't leave objectively? Well, if the police are asking you to get out of the car and they're going to hold you, while they maybe see you drinking or whatnot, you might not feel free to leave, and you can make the argument that a reasonable person objectively would not be free to leave. So you want to tease out that fact. He subjectively believed he couldn't leave. How does that play into a custody analysis? A big fat paragraph. That's the fact to play with. I'm going to say that he was in custody because an objective person, a reasonable person, might feel that they're not free to leave. Interrogation. Was he interrogated? Interrogation means a question by police that's likely to elicit an incriminating response. And here, it's important to understand the exact question. It says here, the police officer observed the gun, which was in plain view, and asked Dan if he was the owner. Now, that's an interesting question because it can cut both ways, and you'll see this on the bar all the time. They will ask you things that can cut both ways, so you have the argument. Would asking the person if they own a gun elicit an incriminating response? Maybe. I mean, if they don't own the gun, it's probably going to lead to, well, where'd you get it? Which could lead to an incriminating response. But on its face, that question alone might not be, it might not elicit an incriminating response, and therefore it's not an interrogating question. If it's not an interrogating question, there is no violation of Miranda. And that's what you need to understand, is arguing that particular fact. It's ambiguous on purpose. You'll see on the bar, the facts are ambiguous on purpose. So you can discuss, on the one hand, yes, it could be an interrogating question. On the other hand, no. And how you come out determines whether or not he can suppress his statement. Again, for time, I'm going to move quickly. Here, you could say that he could suppress the statement, or you could say he can't. And it's either answer is valid. Just make sure you come to a conclusion that is reasonable given your analysis. That's it. That's the key. Theft. Larceny and embezzlement are included under theft. So when they say, is he potentially, can he be convicted of theft, you have to understand that theft includes those two aspects. I have about 2 minutes to finish talking to you, and you probably have about 7 minutes or 5 minutes to argue this. So how do you do that? Well, first of all, you do the heading larceny, the taking and carrying away of the personal property of another with intent to deprive permanently. How did he get the gun? He was given the gun by a woman. Did he take it and carry it away? Well, there's some discussion about he intended to bring it to the church and then he intended to take it, but that really is not the key. The key is that he was given possession and custody, therefore not a larceny. So you might put the heading no larceny because you might just put no larceny and then argue it. I think that's a safe way to do it. Embezzlement. Here, yes, probably embezzlement. Why? Because he was given the gun. He was given custody and possession of the gun, but then he decided to keep it. Embezzlement is the fraudulent conversion of the personal property of another by one who's been given legal possession or is in custody of it, been given custody of it. Here, those elements apply. And in an analysis where you're running out of time, you might want to put the rule and say, here's the rule, 1, 2, 3, 4, 5 elements, or 1, 2, 3 elements, and then bracket, go